Hello and welcome to the Tax Roundup for October. And at the start of the month we had a huge amount of activity with reforms being mentioned, legislation passing through Parliament, and then of course on the 15th everything stopped. The government now under Prime Minister Malcolm Turnbull is regrouping their position. Reform is still on the agenda, but we don't know what shape that reform will take at this point in time. We'll keep you updated. This month, however, we're looking at two important cases that have come through, both dealing with people named Thomas, surnames named Thomas. The first, with Michael Carruthers, we'll have a look at is dealing with franking credits and trust income.
Now, the first of our cases dealing with Thomas and the Commissioner, we're looking at a federal court decision that deals with the taxation of trusts and trust income to beneficiaries. Now, it's quite a complex set of facts, but in brief, what happened was we had a trust where the trustee had resolved to distribute franking credits, so not the franked dividends, but the franking credits and some foreign income mainly to an individual beneficiary. And on the other hand, a separate resolution was made to distribute the other income, so the other net income of the trust, primarily to a corporate beneficiary. That income included some franked dividends. So the trustee was basically trying to split up the franking credits on one hand and the franked dividends on the other. Now, the ATO basically didn't like that and didn't like the way that the tax returns had been prepared for the beneficiaries and basically issued amended assessments. And the federal court was looking into who was right, the commissioner or the taxpayer. Now, the federal court found in favour of the commissioner. And basically what the federal court said was, well, while the tax laws do allow the streaming of franked dividends, so it does allow the trustee to allocate franked dividends to one particular beneficiary rather than having to spread it across all the beneficiaries. Firstly, the trustee hadn't done that effectively. So the tax laws allow streaming, the trust deed allowed streaming in this case, but the trustee didn't meet the relevant conditions to allow that streaming to be effective for tax purposes. The federal court also was asked to look at the situation of, can you split the franking credits on one hand from the franked dividends on the other? Now, the federal court found that franking credits do have potential commercial value. They are something of value. However, they are not ordinary income and they're not something that is similar to ordinary income, despite the fact that they might be statutory income. They might be income for tax purposes. The federal court found that the franking credits remain attached or effectively stapled to the franked dividends. So where the franked dividends go, that's where the franking credits go as well, despite any attempts by the trustee to allocate the franking credits in a different manner. So what happened here was the streaming attempts by the trustee were not effective for tax purposes. So the franked dividends were basically split between the beneficiaries. The franking credits then followed the franked dividends as well. So interesting case because we've had these streaming rules in the tax system for a little while. Not a whole lot of sort of case law to date in terms of how we actually work through those streaming provisions. So this provides some clarification in terms of how those streaming rules apply in the context of franked dividends. Now, it's worth also pointing out that the streaming rules that have been introduced into the tax system do also allow the streaming of capital gains. So franked dividends and capital gains are those two main types of income or gains that can be streamed, but you do need to be really careful to make sure, one, the trust deed allows streaming, and also that the trustee has followed the requirements to allow that streaming to be effective for tax purposes. Unfortunately, in this case, it just wasn't. The other key point here was obviously that the franking credits remain attached to the franked dividends. You can't split those two up from a tax point of view, despite what the trust deed might allow, despite what the trustee might be trying to do. So a couple of important things just to be aware of when it comes to taxing trusts and attempting to stream income.
In our second case, Rae's going to take you through yet another self-education expense deduction claim, this time looking at what happens when somebody is made redundant part the way through their course. Over to you, Rae.
And now another case for another taxpayer called Thomas. No relation as far as we know. This case deals with self-education expenses. So Mr. Thomas was working for a bank and he wanted to undertake further study. He'd done some research and figured out that a specific MBA, which was going to take place overseas, was the best course for him. His employer was generally supportive of this, no issues there. So he enrolled in the course, did the prep that was required and paid the first instalment. A while after that, he was made redundant. He decided to go ahead and do the course and incur the visa fees and everything, go and do the course overseas. The second and third instalments were paid while he was still unemployed. Now, initially he tried to claim all the deductions on the basis that he was firmly committed to doing this course at the time of when he was employed, so there was a definite nexus with his assessable income. The Commissioner disagreed, and unfortunately for the taxpayer, so did the AAT. What happened in the end is they said, yes, we certainly understand that there was a nexus with your assessable income, your income producing activities at the time you enrolled in the course and at the time you paid the first instalment, so there's no problem with those deductions. However, when the second and third instalments were paid, the taxpayer was not earning any income, and therefore there was no nexus with any assessable income producing activity. Therefore, those deductions were disallowed. Self-education expenses come up a lot, and particularly with the third level education courses, they can be really, really expensive. So it's important to bear in mind that there has to be that strong nexus between this particular expense and the income producing activity at that time. If something changes along the way, even though the expense may have been committed to earlier, it hasn't been incurred until they're making the payment, and if that income producing activity is not there or has changed, that can impact the deductibility.
And that's the tax roundup for this month. If you're not a member of Knowledge Shop, give Julie a call on 1800 800 232 and let us show you how we can make a difference to your practice. Speak to you soon.